Hello, I am Flavio Guberman, Head of Corporate Business and International Law Department in our firm. I'm quite glad to have this opportunity to talk to you again. In our previous conversation, we have discussed about arbitration in Brazil, give you an overview of conceptions, ideas and explaining how arbitration works in our country. We also have told you about the arbitration legal frame in the country and how the law and the society had evolved, making arbitration more effective and even attractive as a valid alternative, costs and time considered. As previously said, the morosity of any judicial system is perceived as one of the most crucial issues companies and individuals are confronted to. Today, arbitration is under discussion again. A wide range of modifications will occur, as we have explained in our late video. And so, it's interesting to talk further about the changes and perspectives. Therefore, in this presentation, we will continue to develop the theme, expanding some conceptions and presenting new perspectives about the reform. In Brazil, arbitration operates under the framework established by Law number 9307 of 1996, the Brazilian Arbitration Act. Arbitration in Brazil is consensual, meaning parties must agree to resolve their disputes through arbitration. This agreement can be in the form of clauses in a contract or a separate agreement entered into after a dispute arises. Once parties agree to arbitration, they select arbitrators to resolve their dispute, and the proceedings are conducted according to the rules agreed upon by the parties, or, in the absence of such agreement, according to the rules chosen by the arbitrators. The Brazilian Arbitration Act provides for the recognition and enforcement of arbitral awards in a manner similar to court judgments. Brazilian courts play a supportive role in arbitration by assisting with certain aspects of the process, such as the appointment of arbitrators, interim measures, and enforcement of awards. We kindly ask you to watch our previous explanation about arbitration, where we have introduced you the conceptions, developments, and the history of changes and evolutions on the subject. And in the National Congress, some new discussions about arbitration are being held. Those discussions are intending to reform, improve, update, and modernize the Arbitration Act even further. The new bill is being discussed in the Chamber of Deputies since 2021. The very core of these changes is to enhance the efficiency of arbitration, mainly measures to expedite the appointment of arbitrators, simplify procedural requirements, and reduce the time and costs associated with arbitration. There also have been debates about the further regulation of third-party funding in arbitration, introduced in 2015 reform. Third-party funding in arbitration refers to a situation where an external party, known as a third-party funder, provides financial support to one of the parties involved in an arbitration proceeding in exchange for a share of the potential award. This funding arrangement allows parties with limited financial resources to pursue their claims without bearing the full cost of the arbitration process. The third-party gain can also be an indirect one, derived from a parallel commercial interest or similar. In Brazil, third-party funding in arbitration has become increasingly common, particularly in complex commercial disputes where the cost of arbitration can be substantial. However, it is worth noting that third-party funding arrangements must comply with certain legal and ethical standards to ensure fairness and transparency in the arbitration process. And it is exactly why there are so many claims of a strict regulation on this matter. While third-party funding is not specifically regulated under Brazilian law, it is generally permitted and accepted as a legitimate means of financing arbitration proceedings. However, parties and third-party funders should ensure that their funding arrangements comply with applicable laws and ethical standards. The law will provide such standards, although ethics and moral were not supposed to be enforced by law. Confidentiality is another matter. Third-party funding agreements are typically confidential and may be subject to confidentiality provisions to protect sensitive information about the funding arrangement. This helps to maintain the integrity of the arbitration process and avoid any potential conflicts of interest. On the other hand, there are some who defend that any third-party funding should be disclosed on the very same ground to help to maintain the integrity of the arbitration process and to avoid conflicts of interest. In our current law, third-party funding is not regulated, so there is no obligation of disclosing such information. In some cases, parties may be required under previous agreement to disclose the existence of third-party funding arrangements to the arbitral tribunal and the opposing party. This disclosure helps to ensure transparency and fairness in the arbitration process, allowing all parties to assess any potential conflicts of interest or bias. But there is no legal obligation. In the name of transparency and fairness, the new bill brings that whenever exists a third-party funding, it must be disclosed. Another reason for the disclosing is the impartiality of arbitrators. Arbitrators must remain impartial and independent throughout the arbitration process, regardless of any third-party funding arrangements that may exist. Any potential conflicts of interest should be disclosed and addressed promptly to maintain the integrity of the arbitration proceedings. Therefore, it should not exist secret arrangements or fundings. Another point that is being debated and improved is the recovery of a third-party investment. Arbitral awards resulting from proceedings funded by third parties are generally enforceable in Brazil, provided that they meet the requirements for enforcement under Brazilian law. Third-party funders may seek to enforce any awards in their favor to recover their investment, subject to any applicable legal procedures. The recognition and regulation of third-party funding will expedite such procedures. Overall, third-party funding can provide valuable financial support to parties involved in arbitration proceedings in Brazil, allowing them to pursue their claims effectively and efficiently. However, it is essential for parties and third-party funders to carefully consider the legal and ethical implications of such arrangements to ensure fairness and integrity in the arbitration process. Arbitration involving contracts with the government in Brazil, as we briefly explained on our previous video, is a very sensitive matter, social and politically speaking. Arbitration, as a means of resolving disputes arising from agreements or contracts between private parties and government entities, is a possibility, and the reform will regulate and enhance such possibilities, very seldom used. These contracts can encompass various areas, including public procurement infrastructure projects, concessions, and public-private partnerships. In Brazil, disputes arising from contracts with government entities are generally considered arbitrable, meaning they can be resolved through arbitration if the parties have agreed to arbitration as the method of dispute resolution. However, there may be limitations or restrictions on arbitrability depending on the nature of the dispute and the applicable law and regulations. Arbitration involving government contracts requires the consent of both parties, the private party and the government entity. This consent is typically expressed through an arbitration clause included in the contract, which specifies that any disputes arising from the contract will be resolved through arbitration rather than through litigation in the courts. While arbitration is generally favored as a means of dispute resolution in Brazil, there may be certain public policy considerations that affect the enforceability of arbitration agreements involve government contracts. These considerations may include issues related to transparency, accountability, and the protection of public interests. It is why new provisions are needed to reinforce the parties that there will be no revision. A new legal framework must come to light to provide contracting parties and those opting for arbitration with legal certainty that any decision established in an arbitral award will not be annulled by subsequent judicial proceedings or by political ideological issues of later governments. Disputes involving government contracts may involve special procedures or requirements, such as notice provisions, administrative procedures, or specific regulatory frameworks that govern the resolution of disputes with government entities. Parties to arbitration involving government contracts should be aware of these special procedures and ensure compliance with applicable laws and regulations. The new law must simplify and unify such provisions and procedures in the name of transparency and efficiency. In some cases, decisions rendered through arbitration involving government contracts may be subject to judicial review by the Brazilian courts. While courts generally respect arbitral awards and uphold the principle of party autonomy in arbitration, they may intervene in certain circumstances to ensure that arbitration proceedings are conducted fairly and in accordance with the law. Arbitration involving contracts with the government in Brazil offered parties an alternative and potentially more efficient means of resolving disputes compared to traditional litigation in the courts. But parties should carefully consider the legal and procedural aspects of arbitration, especially when entering into contracts with government entities, to ensure that their rights and interests are adequately protected. Opting for arbitration as a method of dispute resolution offers several advantages over the traditional litigation in the court system. We may list several advantages. First, arbitration proceedings tend to be quicker than court litigation. Arbitrators typically have more flexibility in scheduling hearings and issuing decisions, which can help parties resolve disputes more expeditiously. Arbitration can be more cost-effective than litigation, especially in complex disputes. While parties still incur expenses such as arbitrator fees and administrative costs, arbitration generally involves fewer procedural steps and less formalities compared to court litigation, resulting in lower legal fees and expenses. Arbitrations are often selected based on their expertise and experience in the subject matter of the dispute. This allows parties to benefit from the specialized knowledge of arbitrators who understand the technical and legal complexities of the issues involved. Arbitration proceedings are typically confidential, whereas court proceedings are a matter of public record. Confidentiality can be particularly important in commercial disputes where sensitive business information or trade secrets are involved. Another advantage: parties have more flexibility and control over the arbitration process compared to litigation. They can tailor the arbitration proceedings to suit their needs, including selecting the arbitrator, choosing the applicable rules, and determining the procedural timeline. Arbitral awards are generally final and binding on the parties with limited grounds for appeal. This provides parties with certainty and closure, as they can expect a final resolution to their dispute without the risk of prolonged appeals or further litigation. Arbitral awards are recognized and enforceable in many countries around the world, under international conventions such as the New York Convention. This makes arbitration a preferred method of dispute resolution for cross-border transactions and international commercial disputes. Arbitration offers parties a faster, more cost-effective and flexible alternative to traditional court litigation, making it an attractive option for resolving disputes in various contexts, including commercial transactions, construction projects, employment matters, and international trade disputes. We at Carrion Advogados will be more than pleased to assist you in all your needs, helping you in your case, preparing arbitration proceedings, and representing you, including act as arbitrators, since we have a qualified team of lawyers and accountants able to provide you a work of excellency. Do not hesitate to contact us. We are at your disposal to clarify any doubt and to answer any question you may have on this and any other legal matters.